The first topic for today's discussion is about India's public stock policy and corresponding issues with WTO. This can be correlated to this aspect of the syllabus. This is the background of the main issue. We already know that the current public procurement policy of India is known as minimum support price regime. So what is this minimum support price? It is a price at which government intervenes in the market and procures crops from the market. Usually the MSP is greater or equal to the market price. So what are the main objectives for such a public procurement policy or public stock policy or stocking the food like that? First one is for having remunerative price for farmers. Second one is to have subsidized food for the underprivileged, which is very much essential for our food security. Okay, so what is the issue? The issue is that we are signatory of WTO and a member of WTO. So under WTO law, such a price support based procurement from farmers, it can be trade distorting. How it can be trade distorting? Look, we know that India's main export is wheat and rice to various countries, to Southeast Asia, West Asia, everywhere India is exporting this. So when MSP is increased, the more and more crop is procured by the government. As a result, when the supply increases, we know that as demand increases and as if more and more supply is given, the price automatically falls. So when the price falls, the goods of India or the procured products of India will become cheaper. As a result, it will distort the trade in the global market, which is breaching the WTO's law. So, but what India is currently doing, taking advantage is that India is currently have a temporary relief relating to the peace clause of WTO's agreement, and this peace clause mainly relates to mainly gives concession to the developing country to procure more food for their food security. So, but the real issue is not about WTO's rules or some aspect related to that, but the main concern for India that it should have a policy space to hold the public food stock using MSP, which is a price support instrument. That is, this MSP's main objective is to have a price support. Is not related to that public stock policy. But what have happened so far is that this MSP had become a political tool which have been good for vote bank of farmers. So gradually it became an important tool for the public stock policy. So in order to get more and more vote, this MSP has been increased, and as a result, it is distorting the WTO's law. So what is the new dimension? Currently, India is exporting more and more wheat beyond its public procurement limit. This is because of the vacuum created in the world market due to Russia and Ukraine war. These Russia and Ukraine are the important suppliers of wheat in the global market. So India wants to capitalize on this opportunity. However, WTO law prescribes countries from exporting food grain procured at subsidized prices. That is, WTO put a limit to the export which is procured at subsidized prices. Why such an economic rationale is kept beyond this? This is because allowing a country to export will surely have an unfair advantage to the global agriculture trade. That means such a country will have an unfair advantage for the global agriculture trade. and also it might depress the global prices and have an adverse impact on agriculture trade of other countries. So this is the main economic rationale behind it. So what is the latest dimension relating to this? So already according to the paragraph 10 of the Geneva Accord, uh, there can be waiver on the WTO policies to have release of surplus food stocks to the international market. So the WTO have already agreed this at unexpected circumstances. India has also requested for this, but this request is currently under process. So India, if exports more at this moment, is currently violating the WTO's law. So let us look into some of the historical aspect where there has been a waivers in WTO, which have led to a huge letdown. Recently, WTO has adopted an IP waiver for COVID-19 medical product. The IP waiver is restricted only to COVID-19 medicine, does not cover diagnostics and therapeutics. The shallowness of the IP waiver is further reinforced by the fact that it is limited to only patents and does not cover IP right. That means when COVID-19 erupted, there was a waiver by WTO on its COVID-19 medicine, but this was applicable only to the medicine but not to the diagnostics, and also this was applicable only to the patents, not to the intellectual property rights in that particular country. So if a particular medicine is patent, it can be violated. So according to the author, what should be the main way forward, or what should be the focus of India? India should revisit the waiver asking for the wheat exports in the public stockholding, so which was not earlier as a part of India's public stockholding policies, and also by strengthening India's commitment to the United Nations World Food Programme. This will help in countries facing the food crisis. So India should try to leverage its option in the multilateral platform. So negotiations at the WTO require crystal clarity on the core objectives. Adding to newer objectives, shifting goalposts might result in falling between two stools. That means either you should focus on the food security aspect or should focus on the main price support. Shifting goalposts will create a dilemma among the government policies. What is the patent regime in India? India in 1970s had a product patenting, which was shifted to process patenting in 1970. This enabled India to become a significant producer of generic drugs. So thus India became the global market for generic drugs due to this change, especially in the life-saving drugs like anti-HIV drugs of Cipla in Africa. But due to the obligation of TRIPS agreement, India had to amend this Patent Act of 2005 to support the patent regime across pharma, chemical and biotech sectors. So what is the TRIPS agreement all about? This TRIPS agreement was negotiated in 1995 at WTO, and all the signatories must enact this in their domestic law. And what is the main objective? It guarantees a minimum standard of IP protection. So why such a agreement came into force? Because such legal consistency enables innovators to monetize their intellectual properties. So it helps the innovators to monetize their intellectual properties. In 2001, WTO signed the Doha Declaration. Please listen carefully. These are important aspects for prelims. Doha Declaration, which clarified that in a public health agreement, the government and compelled company to license their patent to manufacturers, even if they don't think that offered price was acceptable. So this is known as compulsory licensing. So during this public health emergency situation, then the government can license such an patent, mainly known as compulsory licensing. This was as part of Doha Declaration. So the next topic for today's discussion is about Prevention of Money Laundering Act. This can be correlated to this aspect of syllabus like government policies and money laundering in paper 3. So what is the contest? In a recent hearing, the Supreme Court of India upheld the constitutional validity of Prevention of Money Laundering Act. The court underlined that the principle of innocence of the accused is regarded as a human right, but that presumption can be interdicted by a law made by the Parliament of Legislature. This mainly means that if there is a person, he remains innocent until he is proven guilty by the court. Proper evidences should be given. But what the current legislation says is that such a precedent of innocence to be proven can be violated by a law passed by the parliament. That means a parliament law can term a person as guilty of an offence even though it is not proven by the court. This was the verdict. So what this background brings is that it enables the reintroduction of an unconstitutional law and also holds the linked bail conditions are not arbitrary. So what the author said, the Indian criminal justice system is based on certain axioms. So what are the important axioms of the Indian criminal system? A person is presumed to be innocent until proven guilty. Okay, he remains innocent until he is proven guilty. And the idea that a person detained on suspicion of having or committed an offence would be entitled to bail pending trial. The idea that a person detained on suspicion of having committed an offence would be entitled to bail pending a trial. That means if a person is suspiciously arrested for having committed a crime, but he can be given bail even though he is pending on his trial time. The idea that criminal law ought to be retroactive. That means it should not be beyond the time date. Okay, we cannot punish a person beyond a time where the law doesn't exist. Yeah, the idea that a person accused of an offence must be informed of the charges made against him. These are some of the important axioms. But today some of these important axioms has been violated in an important judgment given by the court in Vijay Madanlal Chowdhury and Union of India on July 27. What this judgment says, it upheld the vast parts of Prevention of Money Laundering Act despite law inversion seemingly time-honored maxims of the criminal jurisprudence. That means this PMLA verdict uphold the law which contradicts the criminal jurisprudence. Some of the aspects related to some of the key themes in the news that we are looking into this, and the remaining important analysis of this issue will be given in the coming days in newspapers, and we will discuss according to that. So what is this enforcement case information report? This is something which is similar to first information report that we filed in the police station. Okay, it is enough. That means this is the enforcement report that the enforcement directorate gives, and it is an internal document of ED. So another key term relating to this is about section 3 of PMLA Act. This section mainly relates to the main schedules, and offences related to the schedules is categorized in the Prevention of Money Laundering. Mainly defines which are the offences under money laundering. So next is Enforcement Directorate. Enforcement Directorate is currently in news for various reasons because of the raid it is carrying out at high celebrities or high important politicians, etc. The ED's power under Section 5 of the Act about attachment of any proceeding of the crime. So the court rejected the argument that the ED authorities are police officers. So they should be under the control of Article 20, Clause 3 of the Act, where no person accused of an offence shall be compelled to be a witness against himself. So when a police officer inquires a case, he cannot compel a party to give evidence under Article 20, Clause 3 of self-incrimination, which is a fundamental right. So what the Supreme Court upheld is that EDs cannot be considered as a police officer. So they cannot be restricted their duty on this aspect of Article 20 Clause 3. So let us look more into the Prevention of Money Laundering Act of 2002. So what is this act all about? So it is a criminal law enacted to prevent money laundering and to provide confiscation of property. So it helps to prevent money laundering and also provide confiscation of property. So it is a core legal framework for money laundering in the country. It is applicable to financial institutions also. It was amended in 2012. Mainly, it added on the concept of reporting entity for it may be banking, financial institution, and intermediaries. And also, the fine of 5 lakh rupees limit was removed post this amendment. This gave much more power to the officers to have attachment and confiscation of properties. Enforcement Directorate. This is very much important for the aspect of prelims concern. So what is this Enforcement Directorate and this main institution? The Directorate of Enforcement or ED is a multidisciplinary organization which gives investigation on economic crimes and violation of foreign exchange laws. Okay, it is an enforcement unit as a part of Department of Economic Affairs. It mainly works for the Foreign Exchange Regulation Act of 1947. But post-economic liberalization, this FERA Act was replaced by FEMA Act, Foreign Exchange Management Act. So recently, government also passed another important act of Fugitive Economic Offenders Act, and ED is entrusted with the enforcement. So far, the ED is entrusted with important two acts like FEMA and also by Fugitive Economic Offenders Act. Please remember this for prelims. So what are the main functions? The important functions of ED firstly comes from the Prevention of Money Launderers Act. ED is given the responsibility to enforce the provision of PMLA by conducting investigation, and also on the Foreign Exchange Management Act of 1999 to conduct investigation into suspected contravention of foreign exchange laws. So this is all for today's discussion. Please kindly subscribe to the channel for the future discussion. Thank you.